to Off the Record, a podcast on all things law for businesses in Queenstown. My name is Alice Milne.
And my name's Scott Donaldson.
Today we've got a super interesting topic on our hands. It's unit titles. And to join us and talk about it, we've got Julia Batchelor-Smith. She is a director of a boutique law firm, Batchelor-Smith, and they specialise in unit titles. She is a published author of a book on work-life balance, and she's generally a wonderful member of our vibrant legal community. Welcome, Julia.
Oh, thanks so much for having me, to both of you. What an intro as well. I don't quite know where to go from there, but
perhaps you could start by telling us a bit about yourself, Julia, and what brings you to Queenstown.
Yeah, sure. Well, I'm in Queenstown for 4 months of the year now, which is just, I think I'm biased, but the absolute perfect balance.
Yes.
So the rest of the time in Auckland. So I split my practice very much between Auckland and Queenstown. But what's brought me down here is ski racing. My two daughters are members of QUAST, and I sit on the board of QUAST as well. QUAST is the Queenstown Alpine Ski Team for the uninitiated. So yeah,
awesome.
So it's been fantastic just to be down here for the winter and really embed myself within the community. And I've really enjoyed the opportunity to actually really connect with businesses down here as opposed to being a little bit removed back in Auckland. So
awesome.
Yeah,
so 4 months
great.
over the ski season.
Yeah, over the ski season. And then we're back and forth after that as well a little bit too. So the girls, I think I'm going to struggle to get my girls back to Auckland actually. But yeah, my husband's commuting back and forth, so I think he's going to be keen to have us back up there. So we might have to have some discussions at the end of the ski season.
Oh, good stuff.
And your law firm, Julia, specialises in unit titles, is that right?
Yeah, that's right, Scott. So I've purposefully made it very, very specialised. A lot of other law firms have like more of a property focus and a wider focus, but for me, I think it's a really interesting area of law. It's a very human area, and it does really, I think, warrant that specialised attention. So all I do is Unit Titles Act work, be it governance disputes to large-scale remediation projects as well. So there's quite a variety, quite a spectrum within that. But what I really enjoy, I guess, is the human element to it. So I felt that it was time. It's a brand new law firm. It's only a year old, but I did feel that it was time to really kick into that after 20 years within the larger law firms, both here and overseas, and including the past sort of 10 years specialising in construction law. So this is really a subset of that for me, but it's been brilliant. And as I say, the biggest thing for me is it's really, because it's about people and property and homes, it's really coming to grips with that human element of law. So
amazing.
Good on you. Well, this is a really great topic because there's a lot of parts of the Unit Titles Act that are perhaps poorly understood across, even by people who perhaps own unit titles. So this is a topic that we really want to demystify that to people who would be interested. So can you tell us about what a unit title is?
Sure. Yeah, and I think it's such a deceptively simple question, isn't it? But there is a lot of misconceptions around collective living arrangements, and I think what we're going to see as we move into this new era within New Zealand of a shortage of housing and more people looking towards apartments for their first home, and that's where the reforms come in, of course. We need to understand really what it means to own a unit title property. So put really simply, if we take it right back to the beginning, if you go and buy a house that is a standalone property, the land underneath that house is yours. You own the land to that. Now, if you contrast that with a unit title development, when you buy a unit in a unit title development, you own a share of the land underneath your property and, of course, your private property that comprises your unit. So that's really the key difference between a standalone property and a unit title property, is who owns the land underneath your unit. If we take that even further, you might hear in the old terminology talks of unit entitlement, but of course in the new terminology you've got ownership interest and utility interest when we talk about what you actually own within a unit. So if you are buying a unit in a unit title development, you will own your private property, your unit itself, but then you'll also own a share of the common property, and that will be based on your ownership interest. Now, the ownership interest is assessed right at the beginning when the plan is first deposited with LINZ. It's assessed by a registered valuer.
Yeah.
and it is assessed based on the relative value to the other units. So that is the one interest that will be noted on the plan is your ownership interest. Now, you'll also have a utility interest in your unit. That by default can be the same as the ownership interest unless the body corporate resolves to make it a different interest. Now, that's a little bit of a confusing concept for some people, but it really makes sense if you're thinking about from a fairness perspective. If you own a penthouse apartment that uses a lift, for example, it's not necessarily fair for your levies to be the same as someone who's on the ground floor and doesn't use that lift. So what the Unit Titles Act achieves with those two different interests is the ability for fairer costs when it comes to the apportionment of levies and so forth. Another really interesting distinction between ownership interest and utility interest is what they're used to calculate. So your ownership interest is simply used to calculate your share of the property, so to speak. So that's important if you've got, for example, a capital improvement fund. That will be done based on your ownership interest. But in terms of the actual running of the complex, that's going to be very much based on your utility interest, and that's what will be used to apportion the levies. So it seems simple when you think to yourself, oh, I'm going to buy this apartment and that's great and I'm a homeowner, but there are quite a few things to come to grips with, and I think it is worth people just taking the time to really understand what all the different terminology means in practice.
Absolutely.
Well, that's a really great summary, Julia. And the other key concept that people really want to know is, what is a body corporate? What powers does a body corporate have? What control does the body corporate have over what's going on? And what control over the body corporate do individual owners have?
Yeah, and I think that's a great question. So a body corporate is a completely separate legal entity, but it's also confusingly an assembly of all of the owners as well. So for want of a better term, when you buy into a unit title development, you by default become a member of the body corporate. So it is separate, it can contract, it can sue and be sued, it has different rights and responsibilities from the owners, but it is all the owners together as well. Now, within a unit title development, the body corporate owns the common property and is responsible for maintaining and repairing the common property. You as an owner, you've got your own individual rights and responsibilities as well, and of course part of that is making sure that your unit is maintained and repaired. That's on you. But the body corporate is responsible for maintaining and repairing the common property. Now you can imagine this comes with a few issues, and hence why there are people like me who specialise in this area of law, because there are many different ways to skin a cat, I guess, in terms of how the body corporate is responsible for maintaining and repairing the common property. Of course, the key issue is, where does the common property start and unit property begin? And there's no simple answer to that. That's a really tricky thing with unit titles work, is quite often these unit plans have not been looked at by a cadastral surveyor, so they don't know the delineation between common and unit property, and it gives rise to all manner of disputes. And not to bore you to tears with the case law, but there have been some pretty interesting cases around that too, and it's very much a grey area. There was a decision in Mount Maunganui not too long ago where there was a deck on the front of a very large apartment complex, and that deck obviously had absolutely no benefit to anybody else, and this was a very large complex. But it went all the way to the Court of Appeal over who should be responsible for paying for the deck. And ultimately the Court of Appeal said no, that deck is part of the integral weather tightness of the entire complex, and therefore all of the owners must pay a share of repairing it. So you can imagine in these large-scale leaky building claims, there are some really fraught questions to be worked through. Very, very tricky.
Absolutely. And so you mentioned before around some of, well, obviously illustrating some of the disputes that do arise. Is there a mechanism in the legislation to kind of deal with those disputes? Is a big part of your role mediating those disputes? How does that sort of play out in practice?
Yeah, absolutely. And again, I think that's a really great question. question, because people quite often feel really so distraught when these disputes arise, because it's your neighbours, it's people that you'll see in the corridor, it's people that you're getting into the lift with in the morning, so it's highly emotional. Quite often the body corporate managers do play a big role, and we can actually talk about that shortly in terms of the role of a body corporate manager and what it means to be a body corporate manager. But so quite often the body corporate managers will play that first line of defence role, where they will try to see if they can resolve a dispute as it arises. It's going to depend on the nature of the dispute. So some common ones that we see are, for example, somebody deciding that they want to put a sky dish on the outside of their apartment and drilling a hole in the outside of an apartment. Somebody deciding that they, despite the body corporate rules saying no laundry on a balcony, they're constantly putting out all of their dirty laundry on the balcony. Those sorts of disputes are ones that typically you wouldn't have someone like me involved for.
Yeah.
The larger scale ones, yes, they do get tricky, and quite often the body corporate will seek legal advice on those. The way that disputes are to be resolved is changing under the Amendment Act, so that's quite an interesting new addition. So at the moment, the Tenancy Tribunal is arguably quite difficult to access from a cost perspective, and that's meant that it just doesn't make sense often to get lawyers involved because the thresholds are comparatively low, and the fees, I think, from memory, it's $850 for a very simple case, up to $3,300 for a complex case. And as you can imagine, that's quite a barrier to people.
Yes, and the bar of what is complex is actually quite low as well. Seemingly things that are quite simple do actually qualify as complex, meaning people have to pay $3,400 to get into a hearing.
Yeah, exactly, which is a huge amount of money. So under the Amendment Act, which we'll talk about shortly, that is changing. So hopefully that will, I think, make it far more accessible to go to the Tenancy Tribunal. It's now going to be that those categories are removed, and it will be $250 to go to a mediation and $500 to an adjudicator. So it's a massive drop in terms of the fees. But yeah, in terms of disputes, I would just say a lot of this is common sense. If you're living in a unit title development, it is a collective living environment. You can't expect to have the same rights as if you simply live on a standalone property. So there has to be a bit of give and take, and actually quite often a lot of it can be resolved just by good old-fashioned communication. But if you do need to go and get a lawyer involved, that's obviously when the costs will escalate quite significantly. So I guess the dispute, there has to be a proportionality test there in terms of whether or not it's worth getting a lawyer involved.
Yeah. So you mentioned that kind of shared living arrangement is quite distinctive when you compare it to your standalone house in the middle of the suburb. What sort of advice would you give people who are considering purchasing in either purchasing a unit title, they're just generally interested in real estate, or potentially considering a development? Are there certain things that people should bear in mind if they're looking into that kind of legal arrangement?
Yeah, I definitely think so. I think you need to have a really good hard think about whether or not a collective living environment is right for you. Consider your use of the property. Are you buying something as an investment? Are you going to be have it tenanted out? An important thing a lot of people don't realise is that you are responsible as the owner of a unit for your tenants complying with the body corporate rules.
Right.
So that will come back on you. So you need to make sure that you're happy to take that on if you are going to be an investor owner rather than an owner occupier. I think there are fantastic things about collective living, and it is from an ease perspective, it's a really attractive proposition for a lot of people, but you just have to go into it with your eyes wide open. We talked before about the committee. Going onto a committee is actually a really good way of making sure that you've got some control over how your building is run and how the complex functions as a whole, so that people shy away from that, and I can understand why. And actually, it might be quite a good time to talk about committees, because quite often people get confused about what it means to be on a committee.
Do you mind if we just stop, just to backtrack just a little bit? People going into buying an existing unit, what are the kind of things that people would look into or should look into when they're buying a unit. We one other concept that we haven't quite touched on yet is pre-contract disclosure, and we will talk about how that's going to change under the new Act shortly. So what kind of things should people be aware of going into an existing unit title?
I think that's a really great question, Scott. So when you are buying within an existing unit title development, yes, you are entitled to request, and you should very much so request the pre-contract disclosure. So at the moment, under the current Act and regulations, you have 3 types of disclosure. So you've got pre-contract disclosure, and that's obviously before you actually settle. So that's when you've signed an agreement but haven't settled. Pre-settlement disclosure, which is immediately before settlement. And then there's also, at the moment, the ability to request additional disclosure. So pre-contract disclosure will cover the typical types of things that you might expect. So things like the body corporate minutes, there will be some information there on weather tightness, which is going to be expanded quite significantly under the Amendment Act. And it's very important that you go through that and with your lawyer and just make sure that you're happy with everything that is within that pre-contract disclosure. And pre-settlement disclosure is another important aspect of that, because what that's going to tell you are whether or not there are any claims currently against the body corporate. That the body corporate is involved with, not currently against the body corporate, and also whether or not there are outstanding levies and what the levies are for that particular unit. So again, very important facet. The additional disclosure is a bit of an interesting one, and that's actually been completely taken away under the Amendment Act. But that you may have to pay a fee for that information, but that was simply further information bolstering and supporting what you've already requested. So I think it's quite positive. So in terms of the changes under the Act, so the Amendment Act that has now been passed into law in May this year, but has not yet come into force, is really going to have some quite big ramifications, I think, for buying and selling unit title property, and that's a great thing. You know, I think it's fantastic that we've got some reform in this area. I think that people are going to be looking far more at buying unit title property, and anything that we can do to increase the confidence in the market is a really great step. But in terms of the changes, the pre-contract disclosure now is very, very broad. I think it's going to be a real source for disputes, and you're going to have to be very careful to make sure that you disclose everything that you need to. And this is particularly in the area of weather tightness. So at the moment, under the existing regime, you need to disclose whether or not the building has been the subject of a claim. It's pretty narrow and pretty easy for people to understand. It's currently arguable whether or not you need to disclose reports. I always advise my clients it's advisable to do so, but there are some people that take the view that if they haven't sat on the committee or if they've just not looked at a report, then they can ignore that. I've had that argument run against me. I don't subscribe to it, but it is a view that is out there at the moment. Under the Amendment Act, when the new law comes into force, it's very, very clear that anything that could affect the weather tightness of a building will need to be disclosed. That is arguably, even if it could be really easily repaired. So I think people who are selling are going to have to think very, very carefully and make sure that they're on their game in terms of what they're disclosing. There are also some additional disclosures around earthquake-prone buildings, around insurance, the amount of insurance that's been put in place for the building, and a plethora of other issues, really. So it's going to be very, very important that you come to grips with that and know and have confidence that you're disclosing the right things.
Absolutely. And just sticking on that point about due diligence, one of the two things that I really encourage people to do when they're buying units is, one, to look at how much money is in the bank.
Yes.
How much money is in their long-term maintenance account, how much money is in the contingency account, and that will give you a really good idea about whether or not you've got a proactive body corporate who's looking at these oncoming issues, or whether you're potentially inheriting something that's going to cost you money at some point.
Yeah, you're completely right, unless of course there are people that do actively go out and try to buy units because they know that there are all these issues, and so then they're going to be able to pick up a bargain. There's a few in
Queenstown. Yeah.
Yes, I think there are a few around here at the moment. But no, you're completely right, Scott, and I think that's a really key component of your due diligence, is just ensuring from a financial perspective, you know, most body corporates do have a professional body corporate manager, but some don't. That's a little bit of a red flag in my view, if you've just got a volunteer who's performing that role. Looking at, it's compulsory for every body corporate to have a long-term maintenance plan, but not a long-term maintenance fund. And that's something that a lot of people don't quite realise, is that you need to have the plan, but not necessarily the fund in order to actually carry out the plan.
That's right.
So that
Pretty
could
fundamental.
be, and that's a bit of a red flag if you're looking at buying a unit in a complex that doesn't have an actual fund. You think, well, hang on, what's going on here? So those are the things that I think are really, really key. Touching on the building manager versus the property manager versus the body corporate manager might be interesting to unpick that terminology a little bit too, because you'll see all of these terms referred to, and actually it's quite confusing in terms of who performs which role. So the most common one is a body corporate manager. Now, as I said before, it's not compulsory for a body corporate to have a body corporate manager that is a professional manager, although in practice most do, and I would say most well-functioning body corporates do have a professional body corporate manager. The role of the manager is being strengthened under the new law that's coming in, and I think that's a really, really great progression in this area as well. But essentially, a body corporate manager will deal with the fund, if they have one, is in place and is set up to back up the long-term maintenance plan. All of those types of administrative functions that are really important. A building manager is interesting, and not every building will have this, although the larger complexes will. And that's somebody who's on the ground, who's there to, deal with the fact if there's been a leak or if there's been some sort of issue. And then a property manager is typically somebody who will run an individual unit. For example, if you've got someone who has a unit that's rented out and lives overseas, they'll quite often have a property manager. So important to get your head around those terms when you're looking at buying in as well.
So of course, unit titles can be very small. They can be 2 units, and they can also be very large, potentially hundreds of units. So what are the key differences between the small units, say 1 to or half a dozen, up to the big ones?
Yeah, it's a really good question. And actually, finally, we've got some clarity under the new Act too, because under the new Act, it does clarify that a large unit titled development is categorised as one with 10 or more units, and a smaller one is 9 or fewer. So that's the line in the sand now. Now, we can have arguments until the cows come home as to whether or not an apartment complex with 10 units is a large one. I expected that to look more like sort of 30 to 40 units, but that's where we are. Now, there are quite a few differences. In terms of the committee, this is under the existing legislation. You don't need to have a committee if you've got 9 or fewer units. And actually it might be easier sometimes if there are only 2 units to not have one. You can still, of course, set one up, but you don't have to have one. With 10 units or more, you do have to have a committee unless the body corporate resolves by special resolution not to have one. So that's quite an interesting distinction. Under the new Act that's coming in, there are some additional requirements for larger complexes, so those 10 units or more. So the main one is that you must have a body corporate manager. A paid body corporate manager, and there are some requirements around the body corporate manager as well, and some new responsibilities which we'll talk about shortly too. So that is an additional cost, I guess, if you're looking at that. From a long-term maintenance plan perspective, you need to now have a long-term maintenance plan that covers 30 years if you're a large unit titled development. So that's quite a big change from 10 years. And if you decide not to have a long-term maintenance fund, remember we talked about the fund being optional but the plan being compulsory, then you need to review that decision once every year. And furthermore, if you're a large unit titled development, you also need to have a professional building specialist help formulate the plan for you. So it's not just a matter of just coming up with what you think the maintenance might look like. There's going to be quite significant costs involved in that as well. So I guess, it does matter if it's a smaller complex or a larger complex from that perspective, because there is going to be this additional layer over a larger complex in terms of cost and complexity of compliance with the law.
You mentioned before, Julia, around a large driver of these legislative changes is to improve the confidence of people that are potentially looking to purchase unit titles, looking at increased disclosure obligations and having people get a sense of what the body corporate actually does before kind of purchasing a unit title. What's your perspective on whether the changes are enough, or has New Zealand, do you think we've got further to go in terms of creating a space where people are confident to both buy in that space, develop, sell, all of those sorts of things? Or are there more changes on the horizon?
Look, I think it's a really interesting question, and this is an interesting time for this space. I think it does show a maturity for New Zealand. If you look at the trajectory of the legislation, we started in the 70s looking at this legislation. Then, of course, the law was significantly reformed in 2010, but many people thought that didn't go far enough. I think that this Amendment Act is good in that it does strengthen governance, both from the perspective of committees, the body corporate itself obviously, and also body corporate managers in terms of codifying some of their responsibilities, making it very clear what they do and how they should do it. I think that's all a really positive step. There are some things that I think potentially are going to be the source of significant dispute. I think there is a lot of detail in this Amendment Act. There are a lot of changes that are coming into force, and we just won't know until they start working their way through real life scenarios to what extent they're going to cause disputes. It's very positive that the Tenancy Tribunal is now going to be more accessible, and I think that's a really great step in the right direction. It's just going to be interesting to see whether or not these reforms have gone far enough. Actually, another really interesting step in the right direction is that previously the regulator, so MB, didn't actually have the powers of inspection and actually enforcing compliance with the Act. So under the current regime, although the Chief Executive of MB was essentially overseeing the Unit Titles Act and bodies corporates, there was no real teeth. But now we do have that compliance regime in place. I think that that's a really positive step in the right direction as well.
Absolutely. There is a trade-off though, isn't there? Because there is, from a libertarian's perspective, you might say, well, do we need all this regulation? People are free to contract with themselves, contract with each other to form these groups, and they can come up with their own rules that suit their own bespoke needs. And now we're dealing with a regime that really is a one-size-fits-all for all unit titles. Is that a fair observation? Yeah,
look, I think that's certainly a valid view. I do think that you do need to protect the lowest common denominator in these kinds of scenarios, and so I'm a fan of introducing, I guess, more stringent regulation in order to protect that person, and particularly when you're talking about first home buyers, because let's face it, we are. A lot of the time you will be looking at first home buyers who an apartment, a unit within a multi-unit complex is the only option for them. And so I think it's really important that we have those protections in place. And I think that the greater clarity that we can bring to this space, the better. And yes, it's collective living, yes, it's complicated, but ultimately it's just down to people and communication and making sure that you are being a good neighbour, and it's really amplified in this setting. You have to be a good neighbour in this setting.
Yeah, and I think that's a really important point in terms of particularly where New Zealand's looking down the barrel of more intense housing, and as intensification becomes a bit of a hot topic with the housing shortage in New Zealand, and no doubt people are going to be being increasingly aware of the complex jargon that sits behind what is the concept of really it's collective living and its potential to resolve some of the housing crisis issues we've got.
Yeah, and I think that's a really, really good point. This is the obvious solution. If you've got a scarcity of land, then you have to go up. If you've got people who are working and living within cities, then the obvious answer to those pressures is unit title intensification. So, the more that we can do to really get people to understand what they're buying into and get them going into these properties with their eyes wide open, I think the better confidence people will have in the market, and that's going to have, hopefully a really positive flow-on effect to society if we can do that.
Absolutely.
As well as unit titles, Julia, there are some interesting other forms of common ownership that we do see in Queenstown in particular. and I'm sure other places as well, things like residents associations. And can you talk a little bit about those other structures that are around and how they differ and also are the same as unit titles?
Yeah, thanks, Scott. I think that's a really, really interesting question, actually, because we do see in Queenstown a number of these developments that are set up as incorporated societies.
Yeah.
The reason for this is to achieve often some sort of cohesiveness amongst the developments. So, for example, you might have a development like Jack's Point where you want to achieve some quite stringent design guidelines in order to make sure that the development as a whole has got cohesive planting, sympathetic roof lines, pitches, materials used, etc., which just adds to the overall aesthetic of the development itself. So quite a good way to achieve that is by setting up an incorporated society. These are sometimes known as, I've seen them termed residents associations, homeowners associations, but they're all exactly the same thing. What the differences between that kind of a setup and a body corporate, again, if you go back to that initial distinction we talked about, is who owns the land underneath your property.
Yeah.
So typically in that type of setup, you've got a series of standalone properties where you own the land underneath your property. Now, there are, of course, exceptions to that, and there are some that have unit titled property on top of that as well, so we won't get into that, but that's essentially the distinction. And it just means that you will still pay a fee, but it won't typically be as much as you would pay under a unit titled development or arrangement. And it will just mean that you are sharing typically in some common areas, but they're more things like shared spaces rather than shared amenities, I guess is the best way to look at the distinction. From a legal perspective as well, the key difference between an incorporated society, residents association, homeowners association on one side and a body corporate on the other side is that you're not legally obliged to have a long-term maintenance plan, and you're not legally obliged to arrange any form of insurance. So I guess they're the key distinctions. But it is interesting in Queenstown because you do see the proliferation of that, and I can understand why. And it'll be interesting to see how that evolves as well.
Mm.
You mentioned before, Julia, committees, and I would echo your thoughts before about encouraging people to get on committees. But we know that the legislation is coming into effect soon, the new legislation, which is going to increase essentially the obligations on those committee members. So what are some sort of things that people need to think about when they're contemplating going on a committee?
Yeah, so again, I think that's a great question because a lot of people might be sitting there thinking, well, I do want to have a little bit more of a hand in how things are run within the building, but have I got personal liability? You know, how is this going to impact me? What are the things I need to make sure that I adhere to? So as it currently stands, yes, there's no way to sugarcoat this. You do have personal liability going onto a committee. There are things that you can do to mitigate that. For example, insisting that the body corporate takes out insurance, which in my view, I think is only fair. If you've got people giving their time on a volunteer basis, I think that they shouldn't have the threat of liability hanging over them. And there are some big changes coming in for committees under the Amendment Act, and I think they're really positive changes. So although at the moment you technically should declare if you've got a conflict of interest, that's now been put into law that you will need to actually actively declare any conflict of interest and run a conflict of interest register. So I think that's a really positive development as well. And you're also going to have to subscribe to a code, which is in the regulations. Again, hasn't yet come into force, but we know what it says. And a key part of the code that I think is really interesting is that you need to commit to developing a real understanding of the Act and the regulations and how that impacts your position on the committee and the running of the committee. So that is quite an all-encompassing, I think, requirement on committee members. But hopefully it'll just really codify what people do already, which is people generally go onto a committee because they have the best of intentions. They want to make sure that the committee's run in a really well-run way and that they have the best outcomes for their building.
Mm. And so I'm sure that being on a committee comes with a host of interesting stories to tell. As a lawyer, having been most likely involved in some of the more meaty disputes and issues that body corporates and committees have to address on a daily basis, Is there any particular story that you've got that you could share with us that stands out?
I have many war stories, and I mean, apart from the obvious incredibly large-scale remediation projects, which have a whole microcosm of so many other stories as part of that. One that really sticks out was the companion cat. So I did have a body corporate client that had a no pets rule. Now that's interesting in itself, because arguably it's a little bit marginal as to whether or not you can have a no pets rule, and I always advise that my clients that it's better to have in the sole discretion of the body corporate, because then that provides you the latitude to say yes or no. But this body corporate, they were a small body corporate. They were pretty keen to make sure that they didn't have pets within the building. However, there was a lady that bought into the building. She had what she termed a companion cat that was of huge importance to her, and after a lot of hand-wringing and some real back and forth, I think it ended up costing the body corporate around $10,000, because we actually drafted a bespoke licence for the companion cat, who was 14 years old, to reside in the apartment. Yes, so that was one that really stuck out for me.
And true testament to the words that you mentioned before around people having a connection, and in its essence, it's shared living in its essence. Yeah,
it really is. Yeah, and it's just understanding actually that when you go into a collective living environment, you have no way of knowing what's going to be really important to other people. So I guess the committee never thought that they were going to have to deal with something like that. Yeah. But those are often the types of things that seem minor to you, but can be actually very major to somebody else.
Hopefully that she had a long time with the cat before it got too old.
Haven't caught up on how the cat's.
So Julie, we've talked about what body corporates are, we've talked about the disputes, we've brushed on a few of the changes that are going to be made, and we've talked about committees and the importance of committees, the importance of managers, and how that role is changing. And so these new changes, are they taking effect now, or when are they going to take effect, or is it still a mystery?
Yeah, well, it is actually still a mystery. I think they're enjoying keeping us in suspense. So technically, the Amendment Act has received royal assent in May this year, so it is technically law, but as you pointed out, it's not yet in force. Now, we don't know exactly when it's going to come into force, but we do know that it has to be 2 years from the date of royal assent, so it's got to be by the 9th of May 2024. But I think it will come into effect earlier than that. So it's really important, I think, that you start to come to grips. If you're a body corporate manager, if you're an owner, if you're sitting on a committee, don't leave it until it comes into force. It's important to start to come to grips with the changes now. If you're a lawyer advising clients on buying unit title property, again, very important to understand those changes to the pre-contract disclosure regime, because they are going to be significant. I think they are going to result in a lot of disputes as well. So it'll be interesting to see how it evolves. I don't think we've seen the back of Unit Titles Act reform. I think this is going to be constantly evolving, and it will bring some quite significant changes for people as it does. But I'm excited about that. I think this is a whole new era for collective living, and that's a really, really positive step forward for New Zealand.
Good stuff. Oh, well, thank you so much, Julia, for coming on today. You've been your wealth of knowledge, and I can sense your enthusiasm for unit titles, and it's really special.
Oh, absolute pleasure. Thank you so much for having me.
And I'd like to also ask you, Julie, just about your book.
Sure.
The work-life balance.
Yes.
What's the title of it?
It's called Balancing Work and Life, a practical guide for lawyers. Yeah.
So as well as your expertise on unit titles, you're also an expert on balancing work and life for lawyers, Julia. So you've written a great book. So tell us about your book.
Oh, thanks. I definitely would not say I'm an expert at all, but thank you. I loved writing the book. Actually, a great part of the book was I pulled together 90 case studies from lawyers from all over the country. It was published a few years ago now through LexisNexis, but that was the component that I loved the most, was getting to talk to lawyers about their experiences with how they managed the juggle, because let's face it, for everyone, not just lawyers, it is such a juggle, but lawyers seem to be particularly bad at it. So I wanted to explore that. It's been it's been an interesting journey, I think, for me as a mother as well, and someone who really wanted to be able to support my kids with all their different activities, ski racing obviously being here, and having a real hand in making sure that they were happy and content. I wanted to explore what it might look like to adopt a non-linear path within the law, and that's very much been how I've ended up doing what I'm doing. I've been so lucky to work with so many amazing lawyers along the way, have supported me in my various iterations through my legal career, but I think I'm really optimistic about the law, actually, and I think it is possible, particularly in this post-COVID era, to do law differently, and that's an exciting new era for the profession as well.
Good on
Absolutely.
you. Well, I can see a lot of work on your future, Julia, with this new unit title. so there's no maybe your work-life balance might not be
challenged.
might tilt in one direction.
Maybe I might have to expand. Yeah. Anyone interested?
Exactly.
Come have a chat.
Oh no, I think it's awesome, and I've loved just even hearing about what you do, Julia. It's wonderful.
Oh, thank you so much. Well, thank you so much for having me. That was brilliant.
Oh, well, thank you once again, Julia, for coming on and sharing your knowledge and enthusiasm. It's great to have you. Can you please let us know potentially how we could either get your book or get in contact with you?
Oh, thank you. Well, the book, actually, I'm about to release an e-copy version of it because it's now out of print. It was a couple of years ago. But in terms of getting in touch with me, I'm julia@bachelorsmith.co.nz. Bachelor Smith with a T in it, not like the single male, as I've been saying my entire life. But yeah, I'd love to hear from anybody who would like any guidance in this area.
Amazing.
Thank you.
Thanks, Julia.
Thank you so much.
See you next time.
See you next time.